We'll now take up case number 21-1450, Alahad versus State of Florida. Counsel.
May it please the Court, Christine Garrity on behalf of Petitioner Zavion Alahad. I'd like to reserve 4 minutes of my time for rebuttal. In this case, the Court is asked to decide what standard appellate courts should use to review pretrial identification procedures for being unnecessarily suggestive. De novo is the most appropriate standard of review because it best addresses the ultimate purpose underlying the suppression issue, which is to ensure that improper police conduct does not result in the jury hearing evidence of an identification where there's a substantial likelihood that the identification is incorrect. I intend on arguing 3 points in support of this. First, de novo review creates consistency and uniformity in the application of law by ensuring that different courts judging substantially the same facts do not reach different outcomes. Just as important, de novo review develops a body of case law that provides law enforcement officers with a more precise standard of what procedures are constitutionally acceptable, so that the officers can rely on those procedures to obtain an identification that will not later be suppressed by the trial court. And third, the trial court is not in a better position than the appellate court to apply the constitutional principles to the facts of the case.
What about to make factual findings?
Excuse me?
What about to make factual findings?
The standard is that factual findings are reviewed for competent, substantial evidence in the record that supports them.
So you'd agree that the trial court is in a better position to make those
To make
findings.
the factual findings such as credibility or historical facts.
So then help me understand why we should have a different standard in the show-up than we do in a photo lineup, right? Because in a photo lineup, that evidentiary call, you'd agree, we have traditionally reviewed for abuse of discretion, right?
I think that all pretrial identification standards should be reviewed for de novo review.
So you're asking us to change the law not just with respect to show-ups, but with respect to all pretrial identifications.
Well, with respect to show-ups, this is not an alteration in the law. This Court's already determined in Walton versus State that de novo review is appropriate in terms of a show-up. And a show-up is what's in front of the Court today.
Well, the State may or may not agree with your reading of Walton, of course, but perhaps maybe you can tell us why you think that's the correct reading of Walton.
Yes, sir.
Could you, I think it's important for the argument here to clarify at step 1 on the unnecessarily suggestive, what exactly it is that the court is supposed to be looking at, because it seems like there's some ambiguity in the case law as to whether it sort of accepts the premise that a show-up is suggestive and it only asks whether it was necessary to do a show-up versus an analysis that's more like what the 4th DCA did here, which is to sort of look at whatever happened on the law enforcement end during the show-up and then kind of doing this amorphous assessment of, you know, what the court thinks about the propriety of whatever was done.
Well, I think that it's important to recognize that the determination of whether it's unnecessarily suggestive is not a fact in and of itself. It's a legal conclusion that's drawn from the historical facts that the trial court finds. This Court's already determined that show-ups are inherently suggestive because they are just giving the witness one choice, one person to choose from. It would stand to reason then that in a case such as this, where there is another potential suspect, showing the witness that suspect as well would reduce that inherent suggestiveness. The district court acknowledged that it was a close call in this case as to whether the identification was impermissibly suggestive. It cited to the Walton opinion, but it applied an abuse of discretion standard.
Did it really, though, in the sense that it seems like the trial court could be read as having decided that step 1 was met and that therefore it was necessary to look at the reliability of the identification, whereas it seems like the 4th DCA kind of preempted that decision at step one and substituted its own view of what the answer to that question was and then cut off the analysis?
Well, I don't read the trial court's assessment of the facts as finding that initial suggestiveness prong was met. In fact, the court said that it was actually struggling to make that determination because of the fact that show-ups are inherently suggestive, and it didn't even begin the process with analyzing suggestiveness. It jumped right to the second prong of the test, the totality of the circumstances.
The one point that the Fourth District seemed to have a problem with was the fact that there were two defendants with similar IDs present when the defendant in this case was apprehended and brought down, yet they chose not to show the second defendant to the witness to see whether she could identify him as the one. Wasn't that the strongest point the Fourth DCA had for having concerns about this show-up? The fact that Nixon was not brought down for a
I do
show-up
think
as well?
that that's accurate. The case law has established that things like the suspect being handcuffed or being surrounded by police officers are not in and of themselves indicative of unnecessary suggestiveness. The additional fact here is that there was somebody else at the scene who matched the description, both the initial description that the witness gave and also the added details that she made at the show-up procedure.
Do you think that there's a possibility that the step one and step two are different enough that it could almost call for different standards of review for each step? I mean, it seems like step one is more law-ish and policy and what do appellate courts think is appropriate police conduct. It seems like step two is it's called application of law to facts, but it's very, very close to just a pure factual determination of whether the ID is reliable. And it seems like on that issue, there's zero institutional advantage of an appellate court over the trial court on looking at that question.
I would agree with Your Honor that the second prong, the weighing of totality of the circumstances, is pretty clearly a de novo analysis. But I also think that de novo...
That's the opposite of what I said, actually. The second step seems to me to be essentially a borderline factual finding. I mean, I know that it's technically considered application of law to facts, but not all applications of law to facts are equal. Some are closer to a pure fact finding, some are more law heavy. This one seems very fact heavy and therefore more appropriately kind of left at the discretion of the trial court. The first step one doesn't seem like it's necessarily in that same category.
Well, I would agree with Your Honor that step one is certainly not in that same category, and there are several practical reasons why that is so. The first is that a de novo review of the first step provides a consistent and uniform standard for what is an acceptably suggestive identification, so that the trial courts know where they should draw that line when they're considering whether to suppress the evidence.
Given the likelihood that the facts are going to be so unique, and given the fact that even under abuse of discretion review, the appellate courts can still sort of identify outliers and they can still write their opinions in a way that sort of, clarifies kind of, the boundaries of what sort of legally is at stake. It doesn't seem like the consistency thing is really that persuasive. I mean, it seems like there would have to be more kind of overlap factually than what is likely to be the reality out there in the world, which is that there's going to be so many variables in all these cases that I don't know that you're really going to have that much precedential value from what the appeals courts say about these things.
Well, I don't know that I agree with Your Honor that there is not a factual overlap on how these identification procedures proceed. There are very limited ways and a very limited number of variables, I think, that go into the actual procedure itself, and it does not seem out of the realm of sort of what's common that the same factual scenario that occurred here will occur in the future, which is when Mr. Alahad was found, he was together with at least one other person who also matched the eyewitness's description of who the shooter was or what the shooter looked like. And that was this man, Nixon. It does not, that is not such a far-fetched factual scenario that it's not likely to occur again. And so in the sense that when the appellate courts review de novo on specific facts, that does give the trial courts some direction on how they should be looking at those facts or similar facts when they occur in the future. When attorneys are arguing really on any legal issue, but particularly on suppression issues, it is always comparing one case and the facts of that case to what has gone on in this case to try to figure out where that line is.
Go ahead.
It seems to me that, there are certain levels, like Justice Curry, I was talking about facts a while ago. That's, for the trial court to make, and is there competent substantial evidence to support the factual findings, right? It seems like on de novo, you're looking at issues of substantive law, like, for example, is a show-up lawful at all? Is it constitutional? That seems a de novo determination as a matter of law. And then when you're looking at something that you should consider for it to be unnecessarily suggestive, like in the Grant case, there are 5 factors to determine whether something is suggestive or not, unlawfully suggestive. What's determined in making that lawful determination seem like probably should be a de novo review to me, because you're establishing as a matter of law what that is, right? But then when you actually go to those 5 factors, for example, and make that determination in the trial, and the trial court makes that determination, why isn't that an application of the law to those facts, and the trial court should be making that determination, and we extend an abuse of discretion review to that?
Can I just clarify, Your Honor, are you asking about the second prong of the test, the totality of the circumstances?
Well, when a trial court reviews the factors to be determined whether this is misleading or not, why isn't that trial court determination of all those factors subject to an abuse of discretion standard of review, as opposed to de novo?
Again, are you asking me the court's factual findings or determining, making the conclusion that it was unnecessarily suggestive? The
conclusion that the trial court reaches based upon all the factors they're supposed to be looking at.
Well, it should be de novo to give, as I said earlier, consistency and uniformity not only to the trial courts when they're trying to determine what is that legal standard, where that line should be drawn, but also because police and law enforcement rely on what the courts tell them is lawful or unlawful procedure when they are putting, collecting the evidence in the first place. And so police and law enforcement need to be able to rely on a somewhat objective line that is drawn, so they know that they cannot cross it, and if they do, evidence would be suppressed.
What's the standard of review for a trial court's determination regarding probable cause?
The appellate courts review that de novo. If it is a
it's the mixed standard, right, on the historical facts.
Yes, competent substantial evidence to support the facts, and they review application of the law de novo. When we are talking about a warrantless search or seizure.
The courts, in terms of, though, it seems like at step one, courts could, under their kind of undisputed authority over pure questions of law. I mean, appellate courts could announce legal rules that said, as Justice Polston, I think, was suggesting, it's per se a violation of due process to not, when the police are faced with 2 suspects who are close enough, it's per se a violation not to present both to the person, or it's per se a violation of due process to put them in handcuffs or surround them with police or whatever. And so those would be legal rules, right?
Yes.
But if the courts choose to leave it at this kind of amorphous, is it unnecessarily suggestive, then the court sort of deprives itself of articulating any kind of legal rules and leaves it to this more kind of quasi-factual determination. I guess what would you say is the legal rule that is being applied at step one? Because the 5 factors go to reliability. Is there sort of a closed set of factors that go in at step one to define what is quote unquote unnecessarily suggestive?
No, I think much like when the court is determining Fourth Amendment issues like reasonable suspicion or probable cause, there is no specific factor test that's applied. It really is whether the constitutional standard is violated is determined by sort of the application of the law to the facts. The court's judgment that it's unnecessarily suggestive. As a practical matter, I think that de novo review provides the parties with tools that they can use in real time to make that call. And by this, I most specifically mean police officers.
How would this determination that Justice Muniz is describing be different than what the trial court does when it weighs sort of the unfair prejudice versus the probative value of evidence, which they do all the time? It's a weighing sort of credibility, reliability determination. It's, I believe, always reviewed under an abuse of discretion standard. How is this particularly different?
Because in this case, we are talking about a larger constitutional principle and a line that the police cannot cross, as opposed to a judgment call about whether something is relevant or whether it is, unfairly prejudicial or overly prejudicial. And so that determination of a 403 analysis really can only be made by an abuse of discretion. But when we are talking about a suppression issue with a constitutional basis, there needs to be a clear line that police know they are not able to cross. The only way that that can really be created is if the appellate courts engage in de novo review, which not only tells them what is not acceptable behavior, but also clearly tells them what is acceptable behavior, so they know how to apply that in the future.
Counsel, you're down to 2 minutes.
Yes, Your Honor, I'll reserve the rest of my time for rebuttal.
Mr. Chief Justice, and may it please the Court, the Fourth District properly applied abuse of discretion review to this question. I'd like to start at the top by clarifying our position in response to some of the questions. We do agree, for instance, with Justice Polston, that there is going to be de novo review of subsidiary questions of pure law anytime you do abuse of discretion review. And so to give an example, the Chief Justice asked about what is the substantive standard for prong one. And I agree, we don't have a neat 5-factor test for prong one in the way that we do with prong two under Neal versus Biggers. But courts, even applying abuse of discretion review, can announce factors that they find to be significant and perhaps even dispositive. It's just that at the end of the day, applying those factors, they will defer where the trial judge's application was ultimately reasonable. And so doing abuse of discretion review, a court might say that when considering whether a show-up is unnecessarily suggestive, you could look at things like whether or not there are multiple individuals who truly fit the description. That's the kind of factor that you would, I think, look at de novo to ask whether, as a pure matter of law, that's relevant to the inquiry. And so you're going to get law clarification, even under the abuse of discretion review standard that we are advocating for. It's just that at the end of the day, in the ultimate accounting, you will ask whether or not what the trial judge did in the balance was reasonable, rather than whether it is what you yourselves would have done.
Say we agree. how do you win this case where you have a physically similar defendant down to the tattooed, tears on the cheek with gunpowder residue on his hands, and only Mr. Alahad is shown to the victim? Using the test you just articulated, don't you lose?
So we dispute the premise of the question that there is actually any physical similarity here, and you certainly can look at the photographs of the two men who, in our view, looked nothing alike except for the broadest, most general description. I think, in fact, if police had done, say, a two-man lineup with Mr. Alahad and Mr. Nixon, who are 8 years apart in age. Clearly, one of them is not a teenager. Clearly, one is a grown man. The facial structures are different. The skin color is different. If those two individuals had been placed together in a lineup, I think we'd be here and the defense's position would be that was an unduly suggestive lineup because the two gentlemen looked so dissimilar.
And that's only relevant at step one anyway. I mean, the reliability thing, because I'm assuming the relevance of the other suspect is on the unnecessary part of unnecessarily suggestive, right?
I'm not entirely sure it's not relevant to both, Your Honor.
How would it be? So how is the reliability of the? Isn't the reliability just based on what the witness was able to observe?
Well, I think it all goes to reliability. But I suppose you can make the argument, and we haven't carefully looked at this question because it's not the way that the case has been litigated, but I think a defendant might make the argument that, well, there was someone out there who resembled me, and had that person been there, the identification would have come out differently. So I'm not prepared to say it wouldn't be relevant under that prong. But going back to the traditional factors that courts have applied here, on law clarification, and this echoes Justice Scalia's opinion in Ornelas, you get very little law clarifying benefits when the legal question is so bound up in the facts that any one precedent is likely to effectively be constrained to whatever the particular factual mix of that case was. We think that that's exactly what you get with out-of-court identifications. Take the Neal versus Biggers factors. The first one is the opportunity for the eyewitness to get a good look at the perpetrator. Even within that factor, there are so many facts that might be relevant, including, was the witness wearing her glasses that day? Was it bright out? What time of day was it? Were there obstructions? Was she tired? How far away were they? If you change one of those facts in the factual mix, you might get a very different result. And so the point is that you don't get the same bang for your buck out of de novo review here because the precedents just don't go as far. Now, the second point on law clarification is that abuse of discretion review does suffice to provide law clarifying benefits. It can just in some instances take a little bit longer. Now, of course, you're going to get the law clarification that I referenced earlier, where when setting out the legal test, of course, you do de novo review. But even when doing application of law to fact, you get law clarifying benefits. It's just you get those not when you affirm, but instead when you reverse. Because on an issue of first impression, the trial judge's channel of discretion might look something like this. With each reversal, the appellate court has told future trial judges, don't do whatever that was, and so the channel of discretion gets narrower and narrower. Justice Curiel.
Let me ask you a question. Just so I'm unclear on what the demarcation point is here between abuse of discretion and de novo when we come into the case.
Sure.
What exactly, if the trial court makes all the factual findings, historical factual findings, and determination as to whether or not the show-up was suggestive or not. Once those factual findings are made and we apply an abuse of discretion standard to it, then what is left for us to do on de novo?
So I think there are certain predicate legal questions before you do the application of law to fact. So if there's a dispute about, in this case, for instance, that there is a question about where certain facts are relevant, prong one, prong two, are they relevant at all? That's de novo review because you look and you say, as a matter of law, a certain fact has legal relevance in a certain place in the analysis. So that law clarification is happening up front and we think is de novo. It's just that when you get to the back end application of law to fact, that's where the deference kicks in.
Can you help us understand, though, this? So a show up is by definition suggestive, right?
The courts have said they're inherently
Okay, the courts have
suggestive.
said that. So all of the work is being done by unnecessarily, right?
I agree.
Okay. So what are the factors then? And this is where the law comes in, right? What are the factors for? It seems like there's this disagreement potentially that the Fourth DCA talks about between the state courts and the federal courts as to whether exigency and all that is sort of the driving force versus all these kind of micro details about it's never necessary for a police officer to say, we think this meets your description, this person, or anything that they would say almost you could say is unnecessary. So what are, and it seems like it's relevant to this question of what the review should be like, because depending on sort of how narrow or broad the necessity inquiry is, it can become more factual or more legal. So
Sure, but again, we don't dispute that when setting out the parameters of the legal test as to prong one, there's going to be some de novo review that happens. This factor is relevant, this fact is not relevant. And I don't take the Fourth District to have done anything differently as to that. In fact, in the footnote, it didn't even purport to decide the relevance of Mr. Nixon's existence to prong one. It assumed, I think, that his existence was relevant, but then it noted in the footnote, well, there's some disagreement about this point. And it's just that the application of law to fact ultimately got deference.
But you haven't answered the question as to how is the court supposed to know what is unnecessarily suggestive? So show up is suggestive. So what is unnecessarily? How are you supposed to do that first part?
So courts can articulate factors, and when they articulate factors, they do so de novo because those factors are a pure question of law. And so, if you look at the body of case law, courts have talked about factors that are relevant, like whether or not police said anything to the eyewitness at the time of the identification that might have funneled the eyewitness in the direction of that particular perpetrator. That's the kind of factor that courts have said is relevant. Now, if there was an issue on appeal about was that factor relevant, I agree totally. I think this is what Justice Polson is getting at. That's de novo review, but that's not what was happening in this case. I think what happened in this case was that the application of law to fact got reviewed de novo. In fact, as I mentioned, the Fourth District seems to just have assumed the relevance of the fact that Mr. Nixon was out there. Justice Carroll, you asked a question of my friend about Walton's facts. Walton is not a show-up case. It's a photo array case. I mean, I looked, the cases that deal with show-ups are cases like Willacy, where the state cross-appealed, and this court applied abuse of discretion review to the question and affirmed as a result. So the more closely on-point precedents, I think, are abuse of discretion. That's relevant to both stare decisis as well as one of the factors we've identified here, which is a sort of history or practice.
Why should the standard be different for those two different categories? That escapes me.
I'm not sure that they should be.
Well, what possibility would there be that they should be different?
No, I think they probably should be the same. Okay. But if you are looking to draw from the precedent that's most closely on point for stare decisis purposes, I think that is Willacy.
We want our precedent to be internally consistent, right?
I agree.
A point like that.
I agree, and we think that all of these out-of-court identification procedures should be reviewed for abuse of discretion. But if you want to draw from the case law, that's the one that's most closely on point. Now, Your Honor asked a question about probable cause, which there are, of course, cases that apply de novo review to application of law to fact in that setting.
Do you think that's wrong?
I'm not here today to tell you that that's wrong. I mean, we may have a litigating position in that in some future case. But I think it's distinguishable in an important respect, which is that Fourth Amendment questions almost never go to the reliability of evidence. In fact, courts often lament when applying the exclusionary rule that they are forced to exclude from the jury's purview clearly relevant and reliable evidence obtained during searches and seizures. The key difference here, and Your Honor was pointing to it, the key difference here is that this issue looks a whole lot more like Rule 403. Where the real issue is reliability of evidence. That's the whole point of the due process inquiry, is to suss out unreliable identifications compared to those that we think are trustworthy.
And that's true about step two, but not step one. I mean, that's sort of what I'm struggling with, is that it seems like your case is super strong as to step two, and it's just not equally strong as to step one?
So I think that both prongs go to reliability. Whether or not, under prong one, the procedure used is unduly suggestive, of course goes to reliability, because you're asking whether...
I'm sorry to interrupt you. I think that depends, though, on the necessarily part. If the necessarily is looking at things like exigency and all that, then reliability at step one doesn't have anything to do with it.
Well, I think on the whole, the inquiry goes to, and there might be constituent parts, but on the whole, the inquiry looks much more like 403. And just as a thought experiment, if you were to assume a world in which the U.S. Supreme Court had never said that the Due Process Clause protects defendants from unreliable out-of-court identifications, defendants like Mr. Alahad could still come before you and make all the same types of arguments that he raises in this case. He would just have to do so not under a constitutional rubric, but under Rule 403. And so, of course, if he raised those types of arguments in the trial court, lost, re-upped them in the DCA, you would instruct the DCA on a 403 analysis to do what they always do, which is ask whether there's been an abuse of discretion. Now, Your Honor asked earlier whether there might be a different standard of review that applies to prong one as compared to prong two. There is some support for that in the case law. The 11th Circuit and the 10th Circuit both do something like that, although they've actually flipped the analysis. So they say that prong one looks more like a finding of fact and therefore gets clear error review, and then they do de novo application as to the ultimate question. But there's certainly an idea in the case law that you could split the baby in that way, and I think at the end of the day, if you were to say de novo review as to the first prong and deferential review as to the second, that's certainly better than the position that Mr. Alahad is advancing, although on balance we still think that this should be deference as to all prongs.
And your colleague didn't really emphasize this in her argument, but I'm just curious about your position on this issue of the fact that it's a constitutional principle at stake, that should sort of push us more in the direction of de novo review.
Right, so we don't think that the nature of the right or the source from which the right is derived should be significant in the analysis. Constitutional rights, rule-based rights, statutory rights can all have an impact on the jury's verdict. So no, I think it's hard to say that the hearsay rule is any less important or that Rule 403 is any less important. I mean, some of what I think Mr. Alahad's argument turns on when they make the point that this is a constitutional issue is that constitutional issue will dictate the party or the conduct of third parties like law enforcement officers. But as we've discussed, there's relatively little law clarifying benefit to doing de novo review here because of the myriad fact patterns that might arise. And so either way, law enforcement are going to have to use their best judgment, and they're going to get law clarification from abuse of discretion review in any event.
Outside of the criminal context, are there other constitutional rights that are reviewed by abuse of discretion? Are major constitutional issues?
Sure. So, Arlington Heights and animus review was a great example where you do clear error review. But even in the criminal context, we've cited in the briefs 4 or 5 different contexts, and that's on an exhaustive list. But competency to proceed, which it's hard to imagine many legal rules that are more important to the outcome than competency. Ferretta, that's in challenges, where there's an allegation that the prosecutor used race in making a strike. All of those things get reviewed for abuse of discretion. And so I don't think it can be the case that the constitutional nature of this rule is dispositive. The last thing that I'll say about standards of review is that one of the considerations that courts have sometimes looked at is whether or not is the significance of the issue to the outcome at trial, and whether or not there are other safeguards that a defendant might invoke at trial to mitigate the harm of any erroneously introduced evidence. And so Justice Ginsburg made this point in Perry versus New Hampshire. There are plenty of safeguards that a defendant can rely on, even in the case where a suggestive identification procedure comes in. The right to counsel, the right to cross-examination, the beyond a reasonable doubt instruction. A couple of examples arise in this case itself. Florida Standard Jury Instruction 3.9c carefully instructs jurors to exercise caution when reviewing an eyewitness identification and lists many factors that they should think about, including factors like the Neal versus Biggers factors. Another example from this case is the fact that a defendant can bring in expert testimony on the reliability of eyewitness identification, and that's exactly what happened here. Mr. Alahad's witness was Dr. Neuschatz, who offered that kind of testimony, and the jury could take it all in. So the point I'd make is that the due process test really is designed to weed out the most suggestive and most unreliable out-of-court identifications. Abuse of discretion review allows courts to do that because when they affirm on abuse of discretion review, they're saying it was not unreasonable to conclude that this identification was not so suggestive as to have changed the outcome, and at that point, all of the other evidentiary safeguards kick in. So I'm happy to answer any questions that the court might have on the merits. But otherwise, I'm happy to submit our case. Thank you.
Thank you.
I'd like to begin by addressing the argument that abuse of discretion provides adequate law clarifying benefits, and I'd like to use the 4th DCA's opinion in this case as an example, because the 4th DCA reviewed for abuse of discretion, and it ultimately found that reasonable minds could differ as to whether the failure to provide Nixon in the lineup or in the show-up was unnecessarily suggestive. And what that means is that in the future, one trial court could find that it's not unnecessarily suggestive, and another trial court would find that it is unnecessarily suggestive. In the first instance, the evidence does not get suppressed, and in the second instance, it does get suppressed.
Right, but I guess the state's position there would be focusing on the unnecessarily piece of the test. If the two suspects are so easily distinguished, they were wearing different color clothes, for example, or they, were very readily distinguished, then it wouldn't be unnecessarily suggestive to put just the one that matches the description before the defendant. So from a law clarifying standpoint, I think we're kind of at the same place where, again, it is a factually sort of sensitive determination. Isn't that really what they're saying? That, the trial court, having made a factual determination, perhaps in this case, that these two suspects were readily distinguishable, found it not unnecessarily suggestive. Are you asking us to adopt a rule that would deprive the trial court of the flexibility to do just that?
I am asking the court to adopt a rule that provides reliability, because in that situation where reasonable minds could differ on whether it's unnecessarily suggestive, that means two courts that come to opposite conclusions, their results are both going to be affirmed on appeal, which means the result that's left over after that is that there is no explanation for if the second person should be included in the show-up procedure, because some courts could find it's necessary and some courts could find it's not. In either way, under an abuse of discretion review, the appellate courts say it's okay. And so that's a problem with that results in an inconsistent application of the law.
Unless anyone else has any questions up here, you can have 30 seconds left to finish up.
Thank you, Your Honor. Based on the arguments this morning, I would ask that the court decide that de novo review is the appropriate standard when courts are asked to review pretrial identification procedures for being unnecessarily suggestive. And I'd ask that the court remand the case to the 4th District Court of Appeal to apply the appropriate standard of review. Thank you.
Thank you. We'll now take a 10-minute recess. Thank you.
All rise.